Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, as the name suggests, we're going to be discussing some specific issues with respect to the immediate family of U.S. military personnel when those immediate family members are either foreign nationals or specifically a foreign national spouse or fiance of U.S. military personnel. When I was first thinking of making this video, I thought about describing it as benefits to U.S. military personnel, but the word doesn't really seem to fit exactly, so I decided not to call it that. This is just specific things to think about for military personnel in the immigration process. So a couple of things. Most notably, there's another video on this website which discusses, or on this channel, which discusses affidavits of support in the immigration context. It should be noted that most civilian petitioners who are trying to bring a fiance or spouse to the United States, they are going to need to go ahead and show 125% of the federal poverty guidelines number in order to go ahead and meet the threshold created by immigration authorities for ability to sponsor an immigrant in the United States. Active duty U.S. military personnel do not need to show 125% of the federal poverty guidelines. Instead, they need to show 100% of the federal poverty guidelines. Another thing to think about with respect to immigration issues for those who are perhaps married to a U.S. citizen who are traveling overseas with that U.S. citizen while that U.S. citizen service member is deployed abroad. Something major to think about is, let's say that individual service member's spouse has a green card. Well, and eventually that couple would like to go ahead and see to it that the foreign national spouse goes ahead and naturalizes to United States citizenship. In that context, while that's certainly possible, in most cases would occur 90 days prior to the 3-year anniversary of that spouse's arrival or adjustment to United States permanent residence based on their marriage to their spousal counterpart, it should be noted that there is a physical presence requirement for purposes of naturalization in the United States. And that physical presence requirement, in a way, is sort of waived for the spouses of U.S. active duty military personnel. So, for example, if someone is based in, say, Japan with their wife, who say their wife is of Thai nationality but has a green card in the United States, that presence on the part of the wife with the husband who is deployed, or who has been stationed, I should say, abroad, that physical presence, notwithstanding the fact it is abroad, it is considered for purposes of naturalization to be as if that spouse was present in the United States. So this is also the same for certain members of the United States Civil Service or the U.S. government who are working abroad and have their spouse with them abroad. For purposes of naturalization determination, that spouse's presence abroad is considered to be as if they were in the United States proper. So again, I guess that's a benefit, notwithstanding the fact that the American citizen perhaps may not want to be stationed somewhere else. That's sort of everyone's given circumstances or circumstantial. But that being said, it is something that is sort of built into the system to allow the physical presence clock to continue ticking for purposes of naturalization while that individual is overseas. Another thing to think about, especially with respect to deployment, and I do apologize to any U.S. military personnel who are watching this video if I'm misusing certain sort of, for lack of a better term, terms of art with respect to the military. But with respect to deployment to, say, a combat zone, another thing to think about is it may be possible to go ahead and expedite various petitions for, say, fiancé or marriage visas or visas for the stepchildren of an American citizen who's about to be deployed. It may be possible to go ahead and expedite those as, again, there's exigent circumstances for processing those petitions rather quickly, as opposed to dealing with that in just the same manner as one would with, regular civilian population. Another thing to think about, and again, no one likes to think of the worst case scenario, but in recent years there have been changes to, mostly through court action, there have been changes to the way that certain U.S. laws with respect to widows of American citizens, and it could be servicemen of American citizens, are going to be treated with respect to things like adjustment of status. In the past, there was kind of a hardline rule that basically stipulated that it would be rather difficult for an individual who was widowed, who was a widow or widower of an American citizen, those individuals to go ahead and get their status regularized. That has been pretty well smoothed out and ironed out, and now widows and widowers of American citizens, servicemen or otherwise, have a much easier time dealing with the immigration apparatus than was the case in the past. But again, I don't think any of this should exactly be termed as a benefit, as American service members are obviously putting themselves oftentimes in harm's way. So it's simply slight differences in immigration, adjudication, and enforcement and processing for those who are in the United States Armed Services.